Hi everybody. My name is Jay. I'm looking for Yu-Chun, and I'm a moderator for this session. Find out. And first of all, let me introduce our panel. And on my left is Jordan Crenshaw, and he's from the U.S. Chamber of Commerce. He's the Senior Vice President and leads of the day-to-day operational activities of Chamber of Commerce Technology Engagement Center. And he works on the privacy working group. And about 350 management comprising nearly 300 companies and trade associations. And he oversaw the U.S. Chamber of Commerce Commission, Artificial Intelligence Commission, on competitiveness, inclusion, and innovation. And he has several. He's a degree. He has an undergraduate degree. I'm sorry, and he has also a Juris Doctor from College of William and Mary. And he's a CIPP, Certified Information Privacy and Professional in the U.S. And on the left is Kyung-Tae Ma, and he's a partner at BKL, and he's member of the Technology Media Telecommunication Practice Group, and he works for many foreign clients and governments as well. And his background is electrical engineering and also computer science background, and his practice focuses on the evolving AI rules and data protection regulations. And he got his Korean bar license in 2014. And he received JD from the National University Law School, and also holds an LLB and BS in Electrical Engineering from Seoul National University. And also he has an MBA from KAIST. And his left is James Scher, and James Scher is the partner in the New York office of Baker Hostel Titler, and he leads the emerging technology teams for digital assets and data management group. And actually, I met him in May in our ABA conference in a similar session, and I was very, very impressed by his presentation. I invited him again to this session.
Jay didn't want to plan another session.
Yeah, we didn't made a original before that. He has several professional credentials such as CIPP in US and Europe, and CIPM, FIP, PLS, and you can find it what it is later. And he has been working as a member of the Sedona Conference working group 1, 6, and 11, and also IEEE Organization Governance of AI Working Group. Okay, thank you. And then next to James is Annie Tu, and she's also the partner at the GBN law firm in China, and she's based in Beijing. She specializes in regulatory affairs in data privacy and antitrust. She has dealt with data protection, antitrust, and other compliance issues. And she now represents leading internet firms and patent owners in private antitrust actions. And she started in the competition law at the College of Law in the University of Illinois at Urbana-Champaign and obtained a JSD degree. Okay. So with that introduction, well, we're going to start our presentation. And these days you can't pass a day without listening AI or artificial intelligence and recently GPT. Now, the history of AI is long. It started from 1685, and then now, like the ChatGPT. And the turning point was Alan Turing's Turing machine in 1936. And this is the, after GPT was announced, and this is the poem was created by GPT 3.5. So in Korean, it's really look like a real poem authored by a human. You cannot see the difference. So there's a difference of GPT-2, GPT-3, and GPT-4. And GPT-4 is a pretty good tool that you can use these days, except that has, you need to be careful about confidentiality. That we're going to mention that in our discussion. And in 2018, the company called LogGeeks did the comparison between AI and lawyer, and then gave the 5 NDAs and have the AI analyze the NDA, and then 20 lawyers to analyze the same NDA. Look at this. Look at this. The 20 lawyers average took 4 hours to review 1 NDA, 5 NDAs. Now, look at the details. There are 30 legal issues mentioned. So 30 legal issues, and then there are like average with A4 size of 11 pages, 133 paragraphs, and about more than 30,000 clauses. Oops. Look at this. The accuracy, accuracy was 94%, and lawyer's accuracy was lower, 85%. So the high performance lawyer is also 94%, but lowest performance lawyer is 67%. The time, look at this time. The AI took 92 minutes. The human took 92 minutes. AI took 26 seconds to review 5 NDAs. So with that, now many law firms are using AI in their practice, legal research, document review, and e-discovery, and so on. We use a lot, but is it safe to use a lot? This is what I'm going to talk about today. So with that, who wants to go first?
Is anybody here scared of this slide? Is this giving anybody flashbacks? All right, we've got honesty, right? That's what we don't get from ChatGPT, so it's good to see that. This is the dimensionality reduction algorithm, and I've included it on decks that I've presented on, I think going back like 5 years now, because the math doesn't really change, unlike us, we're fickle. It's interesting for 2 parts. One is what it means, and I think the second is that it's come up directly in legal practice that I've had within like the past 3 or 4 months. So just to give a little bit of background. So now you'll know. So now you won't be afraid of this. Oh, well, you're going to be afraid of that one. But dimensionality reduction is this concept. So why AI is fundamentally different than us, even if the outputs look similar, as Jay was saying. AI is looking at connections. It's making connections between things. And it's making almost innumerable connections and then trying to feed those back to those connections that matter. And what those connections mean, oh, does this mean? Okay, God bless. All right. Those connections are trying to figure out what matters, even if it's not something we would think of. And those are vectors, right? A vector relationship, how far away you are, how strong it is. And one of the challenges we've seen in the most immediate point within AI practice is if you've got connections you don't want to make, you don't want to inform your decision making. So in the United States, this is what you think of as disparate impact for different protected classes. So with that algorithm is saying, hey, the AI function is going to make connections that we don't want it to make. We don't want to be responsible for. We don't want those connections to inform what's happening. We have to bump up the level of abstraction so it's not telling us things about the data that are going to further inform what happens. So that's dimensionality reduction, trying to take away dimensions from the data that we don't want to use. And in a conversation with a client, in thinking through the application of one of these algorithms, they're like, okay, well, how do we solve for this? And I said, well, what about the dimensionality reduction? We add in an algorithm on top. There's these things called like the pufferfish algorithm, where you can bump up the data and smooth it out so that you're not getting some of these insights. I mean, that's the level of discourse, if you're playing in this area, that you might anticipate seeing over the course of the next couple of years. Which is to say, buckle up, attorneys. And this is usually the point where some attorneys are like, I'm retiring, right? I'm done, so I'm good. But if you're not, if you're here for the long haul, I think that's where we're starting to go with practice. And the math is here, the data is here, but I think we're starting to move into the law first. And that's probably where I can hand it off to Jordan and find a place to speak to that.
Let's see where I'm at. All right. Yeah, why not?
Oops, here's my arrow. There we go. Oh.
Yeah, so what I can get into a little bit of the policy and a little bit of the legal environment, but I have a question first.
We planned everything except the technology, and we didn't opt to give it over to AI.
That's why I'm a lawyer. I can talk tech, but I can't always do it. So, but anyway, so what the U.S. Chamber of Commerce did is that it realized, representing the interests of the entire U.S. business community, that it was important that we develop proactive solutions in regard to artificial intelligence now, as opposed to many of the other issue areas out there like privacy, where federal laws really lagged behind, and industry for a long time decided that it basically when it said we wanted a hands-off approach from government. But we've heard from even a number of our member companies and other companies out there that they're asking for regulation. And so what we did is we put together a commission of experts in academia and think tanks in the business community. We also got two former members of Congress, John Delaney, Democrat from Maryland, who is former head of the AI caucus on Capitol Hill, as well as Mike Ferguson, former Republican congressman from New Jersey, who's on the Energy and Commerce Committee. It was a bipartisan commission that was basically tasked with three questions. One, how do we regulate AI? Two, how do we prepare the workforce? And three, how does the United States remain competitive when it comes to artificial intelligence as the U.S. Chamber? So I'm going to talk a little bit about the regulatory piece, and then I can get a little bit into the state of where the current laws in the U.S. are. But for the most part, what we found is that there were four key takeaways for the most part that we found. Yeah, that's right there. And really what we found is the development of AI is growing exponentially. And over the next 10 to 20 years, virtually every business is going to be using artificial intelligence in some way, either as an employer or a developer. We actually released research even more recently that showed that 1 in 4 small businesses are already using a large language model type artificial intelligence in the United States. And I think that that's something to be said too about how even smaller law firms may actually end up using this technology going forward in the future. The second, though, is policy leaders have to undertake initiatives to develop thoughtful laws and rules for the deployment of artificial intelligence and its ethical deployment. Third, a failure to regulate AI will harm the economies of the companies that use it because there will not be trust without proper and adequate regulation. And fourth, we also found that developing leading countries, through their technological advantages, have developed a well-developed system of individual rights, advanced legal systems, and interlocking alliances with democracies, and are well positioned to make policy recommendations in this space. But what were the 5 real pillars of regulation that we from the Commission? And one was efficiency. And we don't need to reinvent the wheel as it comes to laws as they deal with AI. What we need to do is enforce the laws that currently exist in the books now. For example, there are laws against fraud in the United States that can be deployed by agencies like the Federal Trade Commission with fraudulent use of AI. Second is neutrality, that we should have tech-neutral rules when it comes to artificial intelligence. And those rules should be based on the outcomes of those technologies and not necessarily based upon the tech that is being used. And it's important that any new laws really are gap fillers, they're not overarching new AI regulations. And third is proportionality. The Commission found that a risk-based approach to artificial intelligence was a superior approach than a top-down system of regulations and permissions that companies would have to ask for from regulators. Fourth was collegiality, and that was the need for federal agencies to coordinate. It's going to require an all-government approach, not only in the U.S., but in other governments across the globe, to ensure that AI is regulated responsibly. And fifth is flexibility. There needs to be flexibility for any new piece of technology. And one of the examples that we have is self-regulation, soft law, and I think we saw a little bit of that recently with the White House announcement with the developers of generative AI, with the commitments that were made just a few weeks ago with things like watermarking and involuntary safety measures that they're putting in place. But really, that's where the business community has really come down in terms of a framework for AI. And how to get a little bit later into the current state of regulations if that's what you want to be putting in.
Thank you. We're going to go quickly with our speakers, and then we'll have some chance for Q&A session later. Okay, how about the regulations in Korea?
Hello, I'll try to cover recent regulation developments concerning AI in Korea and possible restrictions on legal AI services. In Korea, the Ministry of Science and ICT, the MSIT, is pressing for the regulation of its AI law, which it proposed to the National Assembly at the beginning of this year. On February 14th, a first draft version of the MSIT bill was passed by the committee of the National Assembly. However, the first draft version, which I will explain in more detail shortly, faced criticism regarding the appropriateness of the level of regulation. In particular, civic groups in Korea have criticized the bill as being too weak on regulation and called for the bill to prescribe greater regulation on AI. If you look into the draft bill, the MSIT stance on AI can be summarized as permissive as a rule, regulation only after the fact. In Korean, 우선 호명 사후 규제. The MSIT's proposed bill on AI aims to foster AI development and does not aim to impose strict regulations. In this regard, the MSIT is preparing its AI guidelines of technology standards to nudge businesses to voluntarily comply with. Also, this is the reason why the MSIT bill adopts a risk-based approach, where AI use will only be somewhat regulated in certain high-risk areas. The draft bill exhaustively lists out high-risk areas including energy, public health, criminal investigation, and financial loans. Many of you may recognize this approach as similar to the EU's Draft AI Act. This approach is an encouraging sign for various industry stakeholders who seek to utilize and benefit from innovative technology as AI. It is understood that MSIT bill seeks to keep any provisions that prescribe limitations or responsibilities to companies utilizing AI to a minimum unless it is used in high-risk areas. The final bill may include provisions that prescribe certain responsibilities for utilizing high-risk AI, including establishment and operation of risk management plans and human supervision. However, the MSITP bill currently does not include any compliance reporting obligations nor any penalty provisions. Despite the recent calls by domestic civic groups to strengthen AI regulation, the MSIT recently announced that it will introduce its AI law in its current form. Let's move on to the data privacy sector. This August, the Personal Information Protection Commission, the PIPC, published the policy direction for safe utilization of personal data in the AI era. This policy statement sets out an extensive outline of PIPC's position on the proper objectives and direction for the regulation of personal data collection and use in the context of AI development. PIPC is the data protection authority in Korea. Although it's not the main regulator for AI technology, the PIPC has displayed interest in regulating data privacy issues that may be linked to the advent and spread of AI technology. Highlights of the policy statement include the legal basis and limitations of using publicly available data in developing AI models. In general, AI businesses encounter cases where they need to use publicly available data, but processing such data triggers the question of whether or not there is legal basis to use such data, because use of publicly available data is often neither based on clear contractual relationships between the data subjects and the data controller, nor on the consent of data subjects. The policy statement indicates a permissive view of publicly available data for AI training data, subject to a balancing test. This balancing test takes account of the utility of the AI model and factors such as the context of the published quotes. Also, the policy statement confirms that use of pseudonymized data in AI training will be permissible, subject to safeguards against re-identifiability. Second, the policy statement introduces AI governance framework into areas of data privacy. This includes risk assessments of AI systems and data accuracy, integrity and transparency principles in data processing within AI systems. Specifically, the PIPC recommends business to evaluate the risks in their AI systems and prepare in advance different responsive measures for different level of risk. The policy statement also sets forth establishment and implementation of plans to avoid data errors, bias, and distortions, and avoid the spread of discrimination and prejudice. This shows that the PIPC may decide to regulate AI service providers to establish an AI governance system in the future. Okay, lastly, legal AI services. There are currently no concrete regulation on providing legal AI services in Korea. However, the existing laws regarding qualifications and roles of lawyers may act as an obstacle to the introduction of legal AI services. Under the Korean Attorney Act, legal services by non-attorneys are prohibited. Article 19 of the Act states that a person who is not an attorney at law receives compensation for providing or arranging legal services, including legal consultation, drafting of legal documents, legal representation and arbitration concerning legal cases shall be subjected to criminal punishment. In terms of legal AI services, if an AI company provides its legal AI service for free to consumers, then the service won't be prohibited because the item B above will not be met. Also, if a legal AI service provider provides general legal knowledge or information, such as legal search engine, it will not be prohibited because it does not provide legal information concerning specific legal cases. However, if a paying legal AI service is smart enough to provide legal information that can assist consumers in taking legal actions or resolving disputes concerning specific cases, then the service will be prohibited by Article 109 of the Upholding Act. In terms of lawyers who's using AI-based tools in their work, this is not prohibited under the Upholding Act, but since AI may generate false answers, lawyers must exercise caution and proper due diligence when using AI outputs. Thank you for listening.
Well, we can review the regulations in the US and Korea, and then the privacy in Korea as well. So let's hear about China.
Thank you very much. And it's starting with China. Actually, in China, I think the Chinese government is applying a pretty much pragmatic, realistic way when it comes to AI regulation. Actually, China's general laws and policies, I think, could be divided into two parts. One is about industrial policy, which is basically aimed to promote the AI industry or AI relevant industries. And the other side would be the regulations that regulate how to provide AI empowered services. And I think actually the industrial policies came up first. It could date back as early as 2017 something. Back then, the central Chinese government came up with industrial policies. It's kind of like a general one to drive and promote AI application across different industries. And then after that, or maybe at the same time, China is also making rules about like personal information protection, data security laws, and cybersecurity laws. So, before the coming up with the draft rules about the AI law, right now China has already a draft law about AI, but the draft rule has not been released yet. And before that, basically, the regulation regarding AI is based on those kind of general laws, not AI dedicated laws. And when it comes to the ethic issues, in China, we do not have one single government agency, regulating AI or be responsible for AI ethics. We have, standard kind of government regulatory framework. And, here what is shown, the National Governance Committee for the New Generation Artificial Intelligence. It's a special committee under the Ministry of Science and Technology. And this committee is responsible for the day-to-day work about rulemaking and coordination about AI ethics issues. And actually above that, we also have the National Science and Technology Ethics Committee. And this committee actually is part of the Central Parties Committee about Science and Technology. It's a kind of like highest level of the policy making and advisory kind of body when it comes to technology. When it comes to technology ethics, the slide is here.
Well, we want to continue your presentation if that's stopping.
Sure. Yeah. Yeah. Oh, okay. Sure. Yeah. So here is a general, landscape when it comes to the laws and regulations and the government bodies. And in terms of the structure and hierarchy of the other rules governing AI, we have law, we have the administrative regulation that's made by the State Council, and we also have departmental rules. Various national standards, quite a lot. It could be made by the industry regulators, or the industry associations, and maybe some local governments. And we also have some like industry self-disciplinary kind of rules. So all those complex rules, they constitute the whole framework of the rules governing AI. And as I said, right now we do not have special laws dedicated to AI, but we do have a law that is dedicated to AIGC, which is released by the cyberspace the administration of the central government. That's a legal framework. Yeah. Okay, the AI regulation is an overview, but this kind of overview is only about AIGC because, as I said, it's released by the CAC, and I think China, because it wants to strike a balance between government regulation and the promotion of the industry. So it's said that it starts from a kind of a small part, which is very relevant to the most popular AIGC right now. So here you can see that in terms of the compliance of the AIGC role, so we have multiple components. One is the training of the data. So basically, the training of the data, it requires the protection of personal information rights and the protection of IP. And the content being obtained from the individuals, for example, you have to comply with the personal information protection law, and you have to ensure that the training data's quality, authenticity, and completeness is good enough. One thing to note is that, in the draft of the AIGC law, actually the requirement is much more rigorous. It said that you have to ensure that you comply with all the relevant laws and make sure the quality, authenticity, and other requirements are met. And in the industries, they have provided strong feedback saying that, hey, it's not possible. Because we all know the nature of AI or AIGC as service providers or technology providers. It's basically impossible to ensure that you can accomplish or you meet all the requirements. Then in the final version of the AIGC rule, actually the wording of the rule has been changed to that you exercise your due diligence and make sure that you can improve your level of protection and the quality of the training data you used when you do the model training. Okay, here is I cannot see. Here is also the compliance of the training. It said that the data automation during the R&D session, you have to. Sorry, cannot see. Okay, no problem. The training of the data, you have to make sure that you do not violate any IP protection law, the personal information protection, and need to use the legitimate content. For example, when you train data, oftentimes you use spider and scrollers, to get this data from the website. And when you use this kind of technology, you need to make sure that you do not violate any legitimate interest or competition interest of other companies. Okay, algorithm filing. So in China, if your technology has the capability or functionality to mobilize social events or can help to provide opinions to the general public, you have to make a filing to the authority. So when it comes to AIGC, oftentimes this kind of technology can be used. And if so, you have to make sure that you make a filing about your algorithm in this regard to the CDC. Okay. The next compliance component is data security and personal information protection. So as our colleague said, even in Korea, it's kind of impossible job to make sure that you get the consent from other individuals for using their data to train your algorithm and formulate your model. In China, actually, it's the same thing. But our law, it's the AIGC rule is just a departmental rule, and it's based on the personal information protection law in China. So still, it has to comply with, for example, you have to have the legal basis to collect this personal information and to use it and share with other people and to dispose it. So basically, you have to have the legal basis. Although in China, consent is not the only legal basis. We still have some other legal basis. But here in the AIGC rule, basically it's released the basic model formulators from the general legal obligations. So as long as you can show basic satisfaction of the meeting the legal basic requirements, you are fine. The next one is about content regulations. Actually, CEC essentially is a content supervising agency. It's not a data protection agency before the coming up of the PIPL, Personal Information Protection Law. So its specialized area is content moderation. So, in China, of course, the respect of the socialist value is one of the most important requirements. But apart from that, also, the respect and the protection of other people's privacy and the intellectual property rights, and also other legitimate interests of other people or companies are also required when you present the content on internet when you use AI-powered technology. Yeah, here is the approaches or the mechanism you need to establish to achieve content moderation. For example, if you are the AIGC service provider, you really have to mark your content. If you use, for example, the deep synthesis technology, to provide content, you must mark it, to differentiate it from the originally generated content. And you have to set up the, complaint response mechanism, because oftentimes as a service provider, you cannot recognize or identify any risk, especially when you are not the original technology maker and you're just at the application level. So you have to set up this kind of mechanism when any complaint comes up and you respond to it and fix potential wrongdoings. And the next would be the block or the mitigation of any illegal content. This is not something new because in our other online content regulations, they also provide this kind of requirements. When as a service provider, you find anything, any illegal content running on your platform, you have to respond to it. For example, you need to block it, you need to keep records, and you need to report to the authority. And if you are the trainer of the, if you are also responsible for training the data, then you need to improve your training or your algorithm to make sure that next time this kind of illegal content will not appear on your platform. The next one is the full life cycle of the management of the AIGC services or the tools. So basically, you have to make sure that your service is reliable and sustainable. And you have to also, as a service provider or platform operator, you need to guide or educate the users on your platform, or the user, or the implementers of your AI GC tool, to make sure that they use this kind of AI GC tool in a compliant manner. And you have to dispose any kind of illegal content or illegal data that is generated or provided through your platform or your AI GC tools. Here is an overview of the global legislation or rulemaking. So basically, as I said, China, in many areas in the data world, China just model on the European Union. For example, China's personal information protection law basically follows the European approach. And right now, the European Union's AI law is about to become effective. But I would say that the Chinese position is a little bit special because on the one hand, China is used to this kind of pretty much interventionist government regulation, but on the other hand, unlike in the European Union, China has very strong industry interest and our technology and AI related industries. So I think it's not in China's best interest to rigorously, as rigorously as the European Union to regulate the AI or AI GC services or industries. So I would say probably China would just follow the AI GC rulemaking methodologies, so to strike a balance between industry regulation and industry promotion. Yeah, I think that's a brief introduction to China. Yeah, thank you.
Thank you, Annie. I'd like to hear more about the US side.
Yes.
So let me throw up the slide.
All right. Let's see. All right, guys. Okay, so what if I told you this was all intentional to show how it's fits and starts for the application of AI to practice of law? That would be a lie if I said that, okay, to be clear. But it is telling, and I'm going to skip over this because this is just scary looking, although the point of these slides is just that it turns out people don't want to save kids. They would prefer to save themselves, and they want to make sure that they're the ones making the decisions. So we'll just skip right back that. Incorporating everything that you heard here, we want to talk about there are differences within AI. AI is a pretty global term, and a lot of where the interest in this in the news has been this generative AI area. However, there's a lot to AI, and if you've worked with clients or you're a client yourself and you've got a history, you may have a lot with robotic process automation, finding things that you can automate that might have been done by a person before. AI, of course, being the general term, and something that's always 10 years away as far as being strong AI that's going to fix everything. So, I want to tell a story that hopefully will pull all this together and about where we are with the practice of AI and law currently. Roberto Bala is somebody that you might relate to. You can look him up on your phone. If you are checking your phone, I will assume you are checking my facts, and then I will call on you, just to warn you, as I say to my 1Ls when I teach. Roberto was on a plane, okay, avionical plane, and his leg was in the aisle. And what do you think happened? Of course, he was struck with a beverage cart, right? He got injured. And he went to find an attorney to see if he could sue the airline. And he was 2 years after the accident. As it turns out, that exceeds the statute of limitations for the type of claim that he was going to bring. But he went to a lawyer, and the lawyer filed the claim anyway in state court in New York. And Avianca in the U.S., you're familiar with diversity jurisdiction, immediately removed the federal court. And the federal court, so the state court practitioner here, I think his name's on there, do you want to see it? Stephen Schwartz. Stephen Schwartz found Peter LaDuca, who was a federal court practitioner, to act as his local counsel. So you've got federal court practitioner that doesn't know airline law, state court practitioner that doesn't know federal law. Great combination. Probably not recommended. And when the federal court practitioner asked the state court practitioner, hey, how do I combat this motion to dismiss for something that's time barred? He said, oh, let me check. I'll research this. And what did he do? Anybody know? Anybody checking on your phone? What did he ask?
ChatGPT.
Louder. Come on, for the back.
ChatGPT.
There we go. It's like where I camp. So, yeah, he asked ChatGPT, and ChatGPT said, no problem. Here are the cases. And filed them in. This leads to what I believe is that moment where, as a young associate attorney, working in this case, big firm New York, this is the moment you dread. So the partner hands you the brief and says, how are they arguing against this? Like, no one defeats this, right? Go find these cases. The associate takes back the brief, checks Westlaw, checks Lexis, checks Google, Bloomberg, nothing's coming back. It's 3 in the morning. You're like, oh my goodness, what kind of money and time did I waste in law school? So I have to go back to the partner and say, I can't find half these cases, right? I don't know what I'm doing wrong. Partner, incredulous, can't find them either. Court can't find them. Comes back to the practitioner. Oh, by the way, here the lawyers start to lie, which is also not a great thing. This is not allowed, I mean, even in New York, okay? Because the judge says, hey, what's the story here? And the state court practitioner who's doing the research, this is, in the US, the scare quotes indicate that perhaps research is not quite the word, but doing the research said, oh, well, I'm on vacation. Federal court has no idea what's going on. So he says, oh, Judge, I'm on vacation. That's a lie. That's a lie that the court found out and put in its order eventually. Long story short, the state court practitioner, where does he go to double check his work? ChatGPT, the mobile version, and we know this because he screenshotted the mobile version of the answers where he'd asked ChatGPT, oh, is this good law? And ChatGPT, ever optimistic, said yes, this is fantastic law. All right, so of course they got sanctioned, they had to pay some money, and the funniest part, they had to write to the judges who were listed in the made-up citations and tell the judges they were sorry, because that was fraud on the court, right? They made up unintentionally, right? ChatGPT merrily going along. And of course the judge wasn't too upset because Judge Castle is going to dine out on these CLEs for the next decade, right? We know that. And it would never happen again, right? It would never happen again, but it happened again almost immediately in the Court of Appeals in Texas. Now, it wasn't dispositive in this way, and I know this is tough to see, but the court looked at what was put together in an admittedly janky filing, that's a technical term, and said, yeah, we don't think you guys really did this. You pulled this together, and it was clearly written by ChatGPT. Don't do that. Don't do that. And a number of judges agreed. So we're not new to AI and its intersection with the practice of law. I want to take you back to those definitions where we were talking about generative AI. There's the flip side of generative AI. Remember, generative AI is creating things. And there is a categorization AI where it's trying to figure things out. And that goes back to that very, very scary, to some of you, diagram and mathematical equation I showed before. But it's not new. We've got some experience with it. In the United States, even back in 2019, we had the Resolution 112 talking about responsible use of AI. And the courts in the US, you should be aware of this, are starting to take note, and there are a number, there were 4 as of at least this summer, that if you were using generative AI as part of your practice before the court in generating papers, you had to disclose it. And you also had to double check your work. Right. The point is, this is a tool. It is not supplanting the practice of law, and we certainly can't trust it because it hallucinates. So I'm going to skip over a lot of this, although you can see it should be relatively axiomatic. I mean, for those of you practicing, you know where the sets of data are, the sources, and a lot of this has been incorporated into these discussions. If you want to take a screenshot of that, you can go home and work on it, let me know for the dimensionality reduction. But we do have some history of it, and I think the things that we've talked about here in the different country-level presentations are mirrored in some of like the broader sweep initiatives that have happened worldwide. And we've just got a couple here. OECD has been kind of a linchpin for a lot of this, like incorporating rules and approaches. But you see some of it within the US and where we've seen the actual law. So anybody here familiar with the AEDT? Does that ring a bell for anyone? So to make sure my audience. So this is the one in red, the New York City Automated Employment Decision Tools Law, the AEDT. That is in force in the United States. New York City, the DCWP, the Department of, Consumer and Worker Protection. There's a law in the books that says if you use AI to make determinations about employment, if you have employees in a location to which they report in the city of New York, you're subject to this law. And it's not telling you not to use the tool in support of your employment decisions. What it's saying is you have a notice requirement, you have to tell people you're doing it, which means you have to figure out what you're doing, and there's actually an independent third-party audit requirement for the use of the tool. The DCWP has set up the criteria that these auditors have to perform by. And then you have to give it upon demand. I've told this story, this joke, so my panel's not going to laugh, but I got one of the most fun questions I've had as a practitioner about this law when a client said, hey, we have a question. Does Staten Island count as part of New York City? And it's kind of a matter of opinion, but more practically, yes, it does. Thank you, New Yorkers. Or people that hate Staten Island, which it's a Venn diagram. So I think that's where we're going. There's practical implications, and New York City got out in front of the head, or got out ahead of the curve there, because it's going to go to notice, it's going to go to understandings, and we've seen within at least the U.S., the FTC has said it's so complicated, and it's difficult to know what you don't know, right? The infamous unknown unknowns. You're going to need help. We're going to force you to have help. And the other interesting part, at least about the AEDT, is it requires notice of alternatives, similar to what we expect to see in the CCPA when they finally get the regulations together about automated processing. It doesn't require you to provide an alternative, just a notice of one. It's set up to do a handoff, and this is the tie back to Jordan for our Q&A. It's set up as a handoff back to other regulatory agencies like the EEOC, here on the far right, which in the United States looks to the protection of employees. There's existing laws. The AEDT is saying, all right, well, you can't use AI technologies to subvert or to move around laws that are already in the books. And this is kind of the last slide I think I'm going to get to before we deal with the questions, but there were these meta-analyses done dating back to the 50s, to Jay's point, where there's been a lot of history of this. And what they sought to do was, what points keep coming back up over and over again within the literature? Like, what points are they trying to make? Where are these concerns? What are they trying to address? And the reason I bring it up is because there's an expectation that these laws are going to start rolling out of the books in countries around the world. And they're not all going to be similar. There's going to be a patchwork, and that's going to exist for a while. There's going to be some juxtaposition among them. But this is likely going to be the direction that they'll go. So to the extent that multinationals are starting to build out programs and policies, we can see at a high level what issues they should be addressing. So if you're building this out, this is I wouldn't say future-proofing, it's not a safe harbor, but it's going to help for the articulation of what's happening. There's going to be less flux if you're working within different things here. And really, this is core, and it's transparency, which I've put up there as a reflection of the law and the research. I don't like transparency because I don't think it's helpful. It's translucency, it's appropriate, like where you can explain explicability of the process and support for it. Because transparency is the diagram or the mathematical equation I showed you before. Who is that helpful to? Anybody? Come on, give me one, please. Right, that's true transparency. That's what's happening within the systems, but that does not tell a story. That doesn't tell the story of someone whose leg was out in the aisle. By the way, don't do that on your flight home. But it's looking at that. We're going to be in a position where the systems are complicated enough. We as practitioners are going to have to tell the story of how it all works together. And I think that's really where we're going ethically, where we've got a gray area that's going to be very important, and it's going to work at scale for how we move forward. All right, so, and I'll leave this one on. This is kind of the last points where this is practical advice. We've worked with, at this point, just about 50 clients on building out internal policy approaches, and at a very high level, these are the types of decisions and points and considerations that we've we've resolved and worked with. And these incorporate what we know of the law, some of the draft law that's upcoming. It's not perfect. It's not. This is not an area where perfection is available and where we know exactly what's happening. But it is trying to set organizations up, both law firms that are using this, I mean, they're not immune to it at all, but also clients who are working within the space. All right, I'm not going to be the last of it's my crazy long bio, but it'll just look really self-aggrandizing. So,
well, thank you so much. I learned that the attorneys in New York don't lie, but GPT may. So I'll open to the floor. Then if you have any questions, then please raise your hand. Okay, Ricky? Oh, sorry. I'll give you a mic.
Thank you very much for your presentation, and each of the presentations were very impressive and interesting to me. And personally, I'd like to discuss with each of you, but now I'd like to concentrate on the U.S. law. Because in Japan, there is a clear misunderstanding that, for example, some are saying that EU prefers the hard law, while the US prefers the soft law, which is non-binding frameworks. It is clearly wrong in many aspects. For example, the EU AI Act has a provision in relation to the code of conduct, which will be applied to the limited risk AI and also the minimal risk AI. And in the United States, as you said, there has already been some kind of state or municipal laws and regulations, and also I understand that White House is about to issue the executive order, and some of the members of the Congress would like to have some kind of codified laws and regulations. So I would like to know what will be the direction of the, especially the federal government of the United States, and what will be, for example, I would like to know what will be the possible situation where the United States will codify the laws and regulations in relation to AI.
Yeah, I can take that. I think there are a few avenues that AI regulation is already happening right now in the U.S. I think what we've seen is some soft law approach, which is the NIST risk management framework. It's a voluntary code of conduct that if companies say that they're following it publicly, then that means that they're subject to an unfair and deceptive practice charge with the Federal Trade Commission. Then there's also the blueprint for an AI Bill of Rights, which is effectively a white paper on the way that the Office of Science and Technology Policy of the White House views AI. It is claimed to not be a binding policy document, although there are folks who actually would like to see it implemented in that executive order that you mentioned. What that Bill of Rights does is it basically creates protections around things like transparency, opening up algorithms to a variety of stakeholders, including journalists. It would require things like disparate impact analyses. It also encourages the protection of privacy. But that's also something that we've seen in terms of a direction. On the agency side, the Federal Trade Commission is actually undergoing a rulemaking right now in what is deemed the commercial surveillance and lax security rulemaking. They have asked 91 very open-ended questions about how privacy and algorithms should be regulated. One question in particular I think is interesting though is should the regulations be economy-wide? I think in light of West Virginia versus EPA and the major questions doctrine, that may be a difficult one for the commission to go through with if they end up going with economy-wide AI rules, because they only have the authority to go after unfair and deceptive practices. But I think it's also interesting to see where the FTC has gone in terms of enforcement. The FTC can only directly go to court and get fines once a company has violated a cease and desist order, or if they have violated a formal rule established by the commission when it comes to unfair and deceptive practices. Because that does not exist yet in terms of algorithms and privacy, what the commission is doing is sneaking in some backdoor normalization of remedies through the consent decree process when they go after companies for already established laws. Let me give you an example. There's the Children's Online Privacy Protection Act in the United States that the FTC is in charge of enforcing and regulating. Recently, in the case of the Weight Watchers case, Weight Watchers was in violation of the FTC Act, not getting proper disclosures for children's data for the analysis it was running, development of some of the algorithms that it was doing. So what the FTC did is they had a settlement agreement in place that said that Weight Watchers would have to destroy any algorithm that benefited and used the data that was obtained illegally under COPPA. We've seen this used in a few other cases as well now. Lena Khan, the chair of the FTC, is beginning kind of a tour to normalize that. She's mentioned that in a few of her speeches. So those are some examples on the federal side. Finally, as you mentioned, the executive order. That's still under DOJ review right now. But what we have at least heard about it is it's a comprehensive set of recommendations, and it's going to put a bridge to regulation in the terms of what we've seen from the White House so far. So that's just on the agency side. I mean, we've seen a lot of congressional as well. Thune and Blumenthal have both proposed bills. Senator Chuck Schumer, the majority leader, is now running impact forums. He's having like 9 of them to like do research and do listening tours. And then there's the comprehensive privacy bill, the APBA, which would require impact assessments and would also bar the collection, for the most part, of sensitive data for companies. So a lot going on in this space, but as similar to China, there's no one single AI rule right now, and that's where we are.
Thank you so much.
Great, thank you. Any other questions? In addition to Jordan's comment, ADA also is just formed the task force for AI regulations. So it's going to be, we're going to put in our work and then probably have some announcement sometime in a few years. A few years, hopefully.
Note two, there's, and you mentioned this briefly, but the IEEE, so that's the not only electrical engineers, but it's like all engineers, that's the big professional body. There's a move there toward establishing professional standards for the use of AI in products. I think they thought of that as like, well, let's just get out in front of the lawyers because no one likes us. And can we develop that as part of the product, like the intake? And it's almost like an extreme of softball where you're saying, well, we're gonna self-regulate within the creation of these types of products in a way that, you know, we're gonna use some of the social norms. And they've really dug in, like they've incorporated a lot of thoughts going back to OECD. Looking to where the law is gonna go. But you've got like this prospective engineer developers. And that, I mean, that's hitting things at the source. It's really remarkable in that way. I mean, my impression of engineers is normally like the can we do this rather than may we do this, right? Is this available? What remote doesn't need 800 buttons on it? Because we could try to figure something out that's overly complicated. How many engineers in the room? Nah, I'm just kidding. Please don't self-identify. We look at this and I think a number of different groups are trying to move toward the same direction. We know how important this is going to be, and leaving it in the hands of less specialized, less educated, and more reactionary people, it's going to be tough. So we're seeing a lot of this, and there's a lot of movement along similar lines, so convergent evolution for it.
Actually, my question also, I mean, will go to probably my US colleagues and also my Korean colleagues. You know, in China, the technology industry and also the AI industry is quite developed. And I think the Chinese government, as I said, is pretty much realistic and pragmatic. It wants to strike a balance. So that's why it does not, right now, it does not regulate AI as a whole, but starts with a single part of AIGC, generative AI. So whether in the near future, for example, in the US or in South Korea, whether you will also, start from a single part of the whole AI world, I think, probably, not probably, but, in the US and in South Korea, young technology sector is also very developed. In the industry stake is pretty much big, probably as big as in China. So whether you will think a different approach of AI rulemaking as opposed to the European Union, which is kind of catch-all AI law. Yeah.
In Korea, as I said earlier, the MSIT stance is a permissive as a rule and regulation only after the fact, because it wants to promote AI industry in Korea. And I expect that the Korean government will wait for EU and USI's development in regulation concerning AI and follow the rules set by the other countries. Yes.
Okay, is it? Yeah, so any other questions? Our time is just 1 minute left. So if you have any questions, just we'll take one more question. Okay, so I think I should say 1 minute. Yeah, AI regulations, it's always dilemma. Is it regulate or just leave it to the industry? They'll always be a dilemma, and then since the privacy regulations has gone up, and I think that each country is still considering that balancing those two, and like Hiroki mentioned that the Europeans has a strong regulations, and the general concept is that the U.S. has a less regulations on AI and the privacy. But when you think about the industry, and then most of the IT companies, the global IT companies are developed from U.S. So the U.S. is more like industry friendly, and European countries is more like they consider other parts. And so when you look at the background, and I can go on with and the Korean background, and then when you look at the history and their mentality, that's how they regulate, how they deal with these AI issues. So we can talk about that later. And any comments or anything from the panel or from audience?
I think the last point to leave with, and I think it's in part because we got the first law, yay. So we've actually seen how clients are reacting to it. I will tell you that without being really careful about how AI is defined within these regulations, it's very broad. You were talking about like how much, you're just focused on generative AI, but the laws that we've started to see are so broad, they can encompass searches within databases. But that's technically automated. Or what they call within employment law knockout questions. Are you 18 or older? If you've got that as a filter, now in getting comments back, there was an appreciation for exactly that. You had like sophisticated parties within the practice saying, does that count? And they're like, well, not really, but yes, sometimes. Which is a fantastic answer to hear. There's a lot of play there. But it was this idea that yes, a knockout question on its own wouldn't constitute an automated decision training. However, if you keep stacking them on top of each other, you're creating an algorithm, right? You're saying, okay, are you 18 or are you from this zip code? Or do you have this experience? Yes or no? A bunch of binary, we'd call these decision trees that work their way up and suddenly have a complicated system. That may not have even been intentional. There were reasons for all of it that were done over time. There's going to be a lot of embedded practices that are going to come under scrutiny. And in the same way that privacy was requiring data mapping within organizations, or should, to find out what's actually happening over decades of data accretion, we're going to see the same thing with practices internally. And part of the attorney role is truly going to be to ask intelligent questions to get to an informed spot so that we can start to do the type of risk analysis that's going to be required within laws that aren't going to be super specific.
Well, thank you very much. Well, if you don't have any questions or comments, I think that we have completed our session. Well, thank you very much.
Yeah.
Thank you.